Hi everyone, Michael Miller, Director of Mediation Services with the Office of the New South Wales Small Business Commission. I'd like to talk to you a little bit today about the New South Wales implementation of the National Cabinet Code for Commercial Leases. First thing to note would be that we have to go back to the regulation that was made. The code's been out for a little while, and each state has done an implementation of that code according to whatever laws that they might have already existing. So in New South Wales, we had the Retail Leases Act, which covered retail leases and not commercial, industrial, other sort of non-retail, but still commercial leases. So the regulation that's been introduced adds to the existing regulation, the legislation, as it is surrounding retail leases and has been for a long time, but it also incorporates the non-retail commercial leases. So the name of the regulation, which you'd need to go back as your source of truth, is the Retail and Other Commercial Leases COVID-19 regulation for 2020. Essentially, these are temporary measures effective 6 months from the 24th of April 2020. And the whole idea is that we try to maximise the number of businesses that can resume after the public health orders have been lifted. One important question is going to be who are the eligible tenants, and the regulation talks about impacted lessees. In summary, it does include retail, office and industrial. The tenants should have had at least a 30% decline in turnover compared to a prior year, month or quarter. Their annual turnover should have been less than 50 million in 2018-19, and you would note that these are the same tests as for the JobKeeper program. I did want to make a point though that just because the regulation may not apply in a particular circumstance doesn't mean that negotiation of an outcome is impossible. If there are some impacts that perhaps don't meet the thresholds, or there might be businesses that don't quite fit, that doesn't mean that negotiation of a deal going forward is not possible. It just depends on the circumstances and the underlying motivators for the parties to that lease. And my office, Mediation Services, we can still assist with general negotiation and also mediation. The regulations in giving some force to the code, the national code that was agreed, they are trying to provide for eligible tenants to be able to seek a rent reduction. That rent reduction is to be proportional to their decline in turnover, and at least half is waived. See, I've made a spelling error there, but that's intended to say at least half is waived. The rest that is not waived, so it's going to probably be half that's not waived, is going to be deferred, and that's over the balance of the lease term. Now, commercial leases can vary in their lease, the fixed term of their lease. It could be that you've got something as small as a 1-year lease. You might have a 5, 10, even a 15-year lease. So the idea is that whatever the balance of the term is, that the deferred amount of any rent reduction is spread out. And the regulation also says no less than 24 months, but it could be a longer period as well. And the regulations also provide that a tenant can't be evicted for arrears if they fall into these categories. They can't be evicted for not staying open. So there are some leases have core trading hours, for example, where tenants are all supposed to stay open at least for those hours. But the tenants impacted under this regulation, there wouldn't be an eviction for that. And that the lessors can't call on security bonds or bank guarantees for that period. What if you do attempt to try to negotiate something and you can't get an agreement, or perhaps you don't even really know how to start that? Many matters can be resolved just through private negotiation, and we're hearing stories of them every day where they really don't need a third party. The parties are quite comfortable in their own negotiations, and they've managed to settle something, usually a short-term arrangement. There's plenty of uncertainty around at the moment about what comes next, but to resolve that uncertainty, parties are able to come to their own agreements. Mediation, though, is still required for retail matters that can't be resolved, and that's under the Retail LAASAS Act. So you'll find that there are, just in normal times, you get matters that can't be resolved through private negotiation, may or may not be eligible or impacted tenants under the code. But mediation is still something that is there, as it always has been, under the Retail LAASAS Act. For impacted lessees and landlords that are subject to the regulation, then mediation is now also required for that during this COVID-19 period. And just a reminder that mediation can be conducted for commercial leases that are not covered by the current regulations as well. There may be pre-existing issues, or the parties may not meet the particular thresholds, but it is still available to try to help people come to the best possible commercial outcome. What if mediation doesn't work? Well, I'm happy to say that there is a very high chance that you will make some good progress through the mediation. If you haven't had any success through your own private negotiations, or you have felt there are barriers that won't allow you to make progress, you should get it into the mediation system that we have. We'll file an application. We'll assign a case manager, and of all of the matters that get filed with us, history has shown, going back a few years now, that more than 90% of the matters filed will resolve prior to a court needing to make a determination for the parties. You can still pursue claims through the normal court systems, but there is this requirement that mediation be attempted. And so for the commercial leasing matters, mediation should be attempted through our office. You should also be aware that there are certain cases which might require urgent orders to be made, and courts can still hear those urgent orders. But I would note that you may be subject to restrictions on what you can do because of these regulations if you're a landlord. So it would be sensible, even when something quite urgent needs to happen, it would be sensible to try and make contact with our office, consider an application for mediation, consider negotiations, but the courts still function to take urgent applications as well. And the court has to have regard to the Code of Conduct principles. That's enshrined in the regulation. I thought I'd touch on some of the principles now. The regulations, as New South Wales has set them out, group them in a different way to just the 1 through to 14. So that's why I've got the numbers consecutive. Number 1, landlords must not terminate leases due to non-payment of rent. So that's an idea that is meant to try and put the brakes on a little bit, not make any hasty decisions without trying to refer back through a negotiation and mediation services. The other one connected to that is that landlords aren't to draw on security for non-payment of rent if they're subject to the regulation. And the landlords aren't to apply any prohibition or any penalties, in inverted commas, if tenants reduce opening hours or cease to trade during COVID-19. So there are obviously a lot of different factors, depends on the business on a case-by-case basis, but the essential idea is that there aren't to be any sort of landlord prohibitions, penalties, consequences if they're closing or reducing hours because of COVID-19. Rental waivers and extensions are another important part of the code that's referred to in the regulations. So it says rental waivers must constitute no less than 50% of the total reduction in rent, where you do find a downturn, and then there is to be a proportional reduction in rent. Then waivers no less than 50%, and deferrals should be spread out over the balance of the lease and for a period of no less than 24 months. The tenant should also be provided with an opportunity to extend its lease for an equivalent period of the rent waiver and deferral period. That can work in both parties' interests. Things are dealt with on a case-by-case basis, and certainly if you're able to resolve an outcome that works for both the landlord and the tenant in the longer term, and ensures the business can get back to doing what it does well, and the tenancy can continue successfully and complete as we return to some more normal type of operations. Then the variations on the term of the lease can be something that becomes very important to both parties as well, to have that security of tenure and also the guaranteed yield for the landlord. Principle 3, landlord must offer tenants proportionate reductions in rent based on the reduction in trade. There is to be a freeze on rent increases, and that any reduction in statutory charges are to be passed on to the tenant as well. So under the regulation, if they are impacted lessees, then all of those things are to apply. Again, we are quite open to helping people to negotiate these things either between themselves, if we can help to empower that, or give some guidance if there's some concerns about it, or if you do need a third party involved to help with the compliance in this regard, then we do have mediators that are prepared to do that. I think that concludes the presentation, so I'd be looking forward to hearing any questions, and whether they be now as part of this presentation, or certainly following up the channels to ask our team more about what is required, what can be done, what can't be done, and what we can do to help in the negotiations. Ultimately, what we're looking for is to support landlords and tenants of commercial leases to come to arrangements that work for both of them. So look forward to hearing from you. Thank you.